Hi, everyone. Thank you so much for joining us today for the UDRP and U Things to Consider in Domain Disputes in 2023 webinar. I'm Natalie Brownell. I'm the Content Marketing Manager at Markmonitor, and I'm here today with my esteemed colleague, Chris Nemi. I'll introduce you to him in just a second, but before we get started, I do want to let you know that the information in this webinar is not and is not intended to constitute legal advice. Instead, all of the information, the content, and the materials available in the webinar are for general informational purposes only. Please feel free to ask questions throughout the webinar. If we have time at the end, we'll address them. If not, we will address them in a follow-up email. And now to the presenters. Today, the webinar is going to be hosted by Chris Nemi. He is a domain name professional with over 19 years experience in the corporate registrar space. And Chris is a subject matter expert on the new GTLD program, on the .brand top-level domains, and he's managed multiple TLDs through all aspects of the program, from application to evaluation, delegation, and launch. He's a thought leader adept at delivering services and support solutions around domain strategy, domain disputes, and domain recovery. So he's very well versed in .brand services, and today you are in very good hands. So with that, if you'd like to take it away, Chris.
Great, thanks Natalie. That's a wonderful warm welcome. We're excited today to be able to share this wonderful webinar session with our viewers to hear these experts come and speak about the Uniform Domain Name Dispute Resolution Policy, or UDRP. So let's get to it, and we'll start with their introductions. Maria Fernandez Marquez is the head Legal Brand Protection Rights Management at Novartis AG. Maria entered the trademark world in private practice in Brazil, then began her in-house career in the mid-90s in Germany. Since then, she has spent time in senior roles in the trademark departments of various pharmaceutical companies of different sizes. Maria has been a member of the management committee of the Pharmaceutical Trademarks Group for the last 20 years. She is now the head of Legal Brand Protection Rights Management at Novartis in Basel, Switzerland, where she supervises the entire spectrum of activities relating to trademark protection and enforcement, copyrights and domain names, which includes complex litigation matters resulting from online and offline infringements. Welcome, Maria. And we're going to go with Brian Beckham, who's the head of Internet Dispute Resolution Section at WIPO, the World Intellectual Property Organization. He's a US trained lawyer who currently leads WIPO's Internet Dispute Resolution Section, which manages ICANN policy matters while overseeing a team that manages thousands of UDRP cases every year. He's also led WIPO's revision of its jurisprudential overview of UDRP case law. Prior to this, Brian was head of legal policy at the new GTLD consultancy Valideus, where he led successful negotiations with ICANN on special contract provisions for .brand new GTLD applicants. Brian also led a WIPO team which successfully proposed the paperless EUDRP to ICANN in 2009. Let's welcome Brian.
Thanks for having me.
Great, appreciate it. And then lastly, Doug Eisenberg is an attorney and founder of the Giga Law Firm, where he's recovered thousands of domain names for clients over the past 27 years, including under the UDRP, as well as the Uniform Rapid Suspension System, or URS, and numerous dispute policies applicable to various country code top-level domains. Doug also serves as a domain name panelist for the leading domain name dispute service providers, including WIPO and many others. He also has published a 14-part masterclass on domain disputes, which is on his website, and he regularly produces a quarterly domain dispute digest. Welcome, Doug.
Thanks, Chris.
All right. Well, now that we've introduced everyone, let's do one more thing before we get down to it. We just wanted to kind of level set and see where people's experiences are this year with the UDRP. So we're going to start with a poll question. And we'd like you to take part in using the polling apparatus on the platform and answer the question: how many UDRP cases have you filed in 2023? You being either, your company, if you're a brand or trademark holder, or, potentially a law firm. So we'll give you a couple of seconds in order to pick your answer there and let us know how experienced you are and what you've been doing this year. Okay. Let's see. All right, well, it looks like we're wrapping up. And the bulk, it looks like 42% of folks have not filed any this year, and then followed by 1 or 5 or less, and then up into the other numbers, and then a very small number have done a lot. Okay, so we'll take that in mind as we continue through the presentation, knowing that it seems like we got a good number of people who are still working on things this year. Okay, and then one other echo, I'll repeat what Natalie said earlier, that we're going to continue to receive Q&A through the Q&A chat function of the platform. So I'll be reviewing those as we go, and if necessary, we'll bring that up or we'll go to the very end and do a closing session with Q&A there. All right. Well, with all that out of the way, Doug, what do you think about the UDRP, and can you lead us off with some background information about it?
Sure, of course. Thanks, Chris. Actually, those poll numbers were pretty interesting, and I think indicate that the first few slides that we have here are appropriate because I'll touch a little bit on the background of the UDRP. So we'll just focus on the slides for a few minutes, and I think the first question to ask, obviously, is what is the UDRP? For those who don't know, it is an acronym for the Uniform Domain Name Dispute Resolution Policy, which was drafted by ICANN, which is the Internet Corporation for Assigned Names and Numbers, in the 1990s, and it went into effect in 1999 when the very first UDRP decision was published. And the UDRP was really created to deal with what at the time was a relatively new problem of cyber squatting. And in those early days, cyber squatters were mostly, enterprising individuals who were registering domain names as .coms that were, in large part, exact matches for very well-known trademarks. And they were doing this before the trademark owners themselves even recognized the importance of the internet and certainly the importance of domain names and the trademark issues that would eventually arise. So in those early days, it was really unclear whether or even how trademark law would apply to domain name disputes. Plus, of course, cyber squatting was, and for that matter, of course, still is, a global problem with domain name registrants and trademark owners located all over the world, often in different countries, which made it difficult and expensive to deal with these issues through traditional litigation in national courts. So the UDRP came along as an alternative to litigation. It's kind of like arbitration, but the point is it is significantly less expensive and significantly quicker than a trademark owner going to court. The filing fees vary among the 6 ICANN-approved UDRP service providers, but the typical fee, as you can see on the screen here, is $1,500 US dollars for a case with 1 domain name and a 1-member panel, and fees can go up from there depending upon the size of the case. Plus, of course, if outside counsel is used, there are legal fees. But suffice it to say that these are usually quite low compared with the costs associated with litigation, in large part because everything is filed electronically, and the typical case consists of only a complaint and sometimes a response. Sometimes it can get a little more complicated than that, but not much. The point is that there are no hearings, there are no motions, there is no discovery, there's certainly no trial. And there are also, for better or worse, no appeals under the UDRP system. The entire process is conducted online and usually concluded in about 2 months, with most trademark owners requesting, and in about 90% of cases or so receiving, an order to transfer the disputed domain name away from the cyber squatter and to the trademark owner, who can then simply shut it down or use it however they want. In rare cases, a disputed domain name is canceled, usually because that's the trademark owner's request, but that remedy is something I almost and probably actually have never recommended to clients, because a canceled domain name then becomes available for registration again by somebody else. Finally, I should note that the UDRP applies to .com And all of the, what we refer to as the new GTLDs, everything, from .AAA to .Zurich. But it has also been adopted by about 42 or so registry operators for CCTLDs, or country code top-level domains. I'm sure we'll talk about some of those in a few minutes as well. So as a result of the UDRP's simplicity and its speed and its effectiveness, Corporate Counsel magazine long ago referred to it as the preferred option for most trademark owners. So we'll just go to the next slide. So what is required in a UDRP complaint? A trademark owner has to prevail by a preponderance of evidence on 3 elements that you can see on the screen here. First, that the disputed domain name is identical or confusingly similar to a trademark in which the complainant, which is the trademark owner filing the complaint, has rights. So that first element itself actually kind of breaks down into 2. You have to show that you do have trademark rights, whether they're registered or common law trademark rights. And then also that the disputed domain name is identical or confusingly similar to it. Fortunately, through the 25 plus years of the UDRP, there is a lot of jurisprudence from previous UDRP decisions that help to explain what confusingly similar actually means. The second element that every trademark owner has to establish is to show that the registrant of the domain name has no rights or legitimate interests in the disputed domain name. This sometimes, can be a difficult element because it requires proving a negative, and not all of the facts are always known to a trademark owner when filing a complaint, in part because, as I'm sure we'll also talk about, the identity of the registrant is not always known. But there are definitions within the UDRP itself as to how a domain name registrant could establish rights for legitimate interests. And then third, and this often becomes sort of the most significant part of a UDRP complaint in many cases, a trademark owner has to show that the domain name was registered and is being used in bad faith. There are some illustrative definitions of what bad faith is in the UDRP policy itself, as well as, again, all sorts of jurisprudence that has evolved from the tens of thousands of UDRP decisions through the years. But the key to keep in mind here is the language of the bad faith element. It's not just bad faith, but it's bad faith with respect to registration and bad faith with respect to use. So on the next slide, as I said a moment ago, a typical UDRP case takes about 2 months to resolve from the time of filing a complaint until the time of getting a decision. Don't need to go through each and every step here, but the point is, as you can see, it is a rather simple process. There is, as Chris mentioned at the introductions, another dispute policy that we're really not going to focus on as much today, the URS, the Uniform Rapid Suspension System, which can be even quicker than the UDRP, but it does not apply to .com domain names and has a number of other significant limitations. But this is the typical timeline for a UDRP case. On the next slide, and then I'll turn it over to the next panelist. But there are a number of common delays that can arise in a UDRP case, some of which you see on the screen here. As I said, a typical case involves the filing of a complaint and a response, but often you don't know who the respondent is. And so during that administrative compliance process, after the UDRP service provider receives the complaint, it may receive information about the so-called underlying registrant from the registrar and provide that to the trademark owner with an invitation to amend the complaint. In some cases, panels may issue procedural orders to clarify certain factual or legal issues. Occasionally, and I serve as a UDRP panelist as well, so I see this maybe more than occasionally. Parties will submit what are called supplemental filings, which are not necessarily specifically allowed except upon the panel's request, but sometimes are admitted. If there's a 3-member panel, that can slow down the process a bit as the parties have an opportunity to give input as to who the members of the panel may be. And then I'm sure we'll talk about this as well too. There are opportunities throughout the course of the proceeding where the parties can settle the case. And then finally, following the decision in a case, there's always, as the UDRP itself requires, a waiting period of 10 business days before the domain name can actually be transferred, if that is the decision that gives a losing domain name registrant an opportunity to go to court to essentially contest the UDRP. But also some domain name registrars, frankly, are either more well-versed in or more cooperative in the UDRP implementation process. And so sometimes the actual transfer of a domain name following a UDRP decision can itself face a little bit of a delay. So with that, I'll turn it back over to everyone else.
Great, thanks, Doug. Thanks for that introduction. Brian, as WIPO is known as kind of the most transparent UDRP provider for giving statistics and other information, can you lead us off with some good resources and statistics?
Yeah, thanks. And just to go back to one thing that Doug mentioned on the other slide, and sorry, actually, I jotted something down. Natalie mentioned at the beginning, and I know Maria would be able to speak to this as well, about coordinating across teams with your counsel, maybe with your DPO. I would say increasingly, and if you're not, maybe think about that. Coordinate with IT, because sometimes you know, there's different people managing domain names from different perspectives, and certainly it's good to make sure that everyone's on the same page. There might be someone who registered a domain name that is actually in your company. We've seen this happen on a few rare occasions where a complaint is filed, and then when the notice of registrant information, which is the registrar telling us who's the actual underlying registrant, because nowadays often you don't know who that is because of GDPR. Basically, everything is under a privacy shield in terms of who's the registrant of a domain name. And we have seen one or two cases where it was actually another department in a company. So of course they can terminate the case and get a refund, but that's something that could potentially be avoided. I put in the link in the chat a link to our search page. There's you can do a word-based search, and you can find some statistics. You can find out what are the most cited decisions in pleadings, things of that nature. But really, what I would say, and of course you can see who we are institutionally, WIPO, on the screen there. People obviously in this audience will know us for having created the UDRP back in 1999, which was then adopted by ICANN. And something that Doug mentioned, that it's like arbitration, but it's not arbitration. In one respect, that's kind of an interesting legal factoid, but there's an important practical aspect of that to bear in mind, which is because it's actually an administrative process that operates through a series of contracts as opposed to arbitration. Under arbitration, if this was an award, then basically it would be binding absent some very exceptional circumstances, and it wouldn't be something you could appeal in court. Under the UDRP, though, this was an intentional design choice by the drafters of the UDRP. It's not arbitration, so it can be appealed to court. And one place where it's really important to think about that, which in my experience I think people kind of gloss over, is when you're filing the case. And I'd be curious, you know, Doug or Maria, if you guys have any tips for this. I mean, it's a fairly obvious point, but it can change some elements of your pleading, which is that if you you have the option when you file the case to either elect the jurisdiction of the courts of the registrar or the courts of the registrant. If they have the option to appeal if you win, but then you basically choose which one or both of those courts they would be able to appeal in. And so with the registrar, you'll know that in advance. So if it's GoDaddy, for example, it's the courts of Arizona, and you can select those as the appeal court if the registrant chooses to go down that path. Now, if you choose the court of the registrant, you wouldn't know that until you get the information from the provider, which gets the information from the registrar. And when we relay that information back over to the brand owner, we do it not only because you're filing instead of against John Doe, now you have a named person. Maybe you can do a little bit of research and say, this person has been a registrant who's lost 500 other UDRP cases. This therefore shows a pattern of bad faith. It's a kind of simplistic example, but I think it's really important you can learn a lot in 5 minutes on Google by looking up the registrant identity, and that can help bolster your case. But the other aspect that I wanted to mention was that you also have the opportunity to amend your pleading substantively, but also in terms of the mutual jurisdiction. And that's something to really pay attention to, because you're basically choosing the court that the registrant would be able to drag you into. And if you aren't paying attention to that, and they're in some jurisdiction where you would have to hire local counsel, and you could avoid that by choosing a different court, that's something that's certainly worth looking at when you get the notice of registrant information from us. But the main resource I would point people to, Doug mentioned the overview, and this was basically, we looked back over tens of thousands of cases, drew out the kind of the core jurisprudential principles. There you see a chart of our statistics. We have been on average 10 or 15% increase in caseload for the past 8 or 9 years. This year looks to be no exception. And we don't really know why that is. We can sort of speculate that, especially after COVID, then everybody's on their computers working and shopping and going to school and so on. So unfortunately, that means that infringers are trying to take advantage of that. We see a real uptick in the past couple years. When I started doing this, it was actually a pretty rare exception that you would see a case involving some sort of fraud or phishing or something to that effect. Nowadays, unfortunately, that's relatively common in our cases. It's pretty open and shut case from the brand owner's perspective, but obviously it's a type of behavior that you have to adapt to. But anyways, so the cases are on the rise, and the core resource I would point people to, especially, it's interesting to see a lot of the people haven't filed a case this year. I don't know if that means they're new to this or they just haven't filed a case this year, but it's our jurisprudential overview. It's about 60 or 70 kind of frequently asked questions. There's a section on each of the substantive elements, and then a section on process, on the procedure. And really, I can't stress enough, this is worth its weight in gold if you're going to file a case. Most of the questions you're going to run across in a case are in there. And in fact, again, in the early days, you would tend to see a lot of string cites in pleadings and in decisions. And nowadays, we tend to see, I wouldn't say we don't see case citations, we still do see those, but we tend to see parties to cases and even panelists making the decisions citing to the overview, which kind of captures at a high level a jurisprudential concept. So that would be my go-to resource every time. On the previous slide, no need to go back to it, but it's so this is our list of CCTLDs that we work with. As Doug mentioned, about half of them have adopted the UDRP. So one kind of practice tip is, if you have a case, and this is more difficult nowadays, but if you have a case where you know the identity of the registrant and you can do a watch report and see that they've registered a number of infringing domain names across both, let's say, .com and .co, for example, you can actually combine those in one case because the same policy applies, so you can get some economies of scale. That's about half of the CCTLDs that you see on the screen. The other half, there's small but sometimes important variations. Sometimes those would account for national law, and so it's in some they would be, instead of under the UDRP, you have to prove both registration and use in bad faith. In some of the CCTLDs, they've said you only have to prove one or the other, so that's a pretty substantial difference. So I can't stress enough, if you're going to file a case under one of these CCTLDs, don't just kind of cut and paste your UDRP model. We've seen that sometimes, and that can be cured, but it's something that's preventable. And so really, we provide each one of these CCTLDs. We have a dedicated page. We give you kind of a high-level snapshot of the differences, the commonalities between the UDRPs. And so again, if you're filing one of these cases, it's really a website that's worth a scan.
Great. All right. Well, thanks for that, Brian. That was some great background and good places to go to get some of that information. So now we're going to pivot into some discussion around brand protection. So before we do that, we want to start with our second poll question, just to see what people are experiencing out as they're, addressing issues around their brands. So let's see, what types of cyber squatting issues are you encountering? Phishing or scams, counterfeiting, pay-per-click, passive or inactive websites, or other? So if you want to throw in your answers, that would be great. All right, let's give it a couple more seconds. Okay, well, not sure where the math went on those percents, but it does look like we're definitely seeing some more activity in the phishing and scams area, and then followed by passive or inactive sites, pay-per-clicks, and then counterfeiting, and then other bringing up the rear. All right, well, we'll keep that in mind and as we go through the rest of the discussion. Maria, let's start with you. So, let's tell us about how, in your role, how your team drives forth Novartis's efforts in the legal brand protection rights management space, and where UDRP plays into that.
Yeah, thank you, Chris. Well, I'm here today to offer everyone the perspective from my industry, and I am conscious that the competitive landscape and issues regarding, for example, illicit trade, counterfeiting, are likely to somewhat differ from industry to industry. But having said that, regardless of the industry you're in, I think it's always a good idea to identify the scenario you're facing. Because this will automatically lead you to identifying the possible enforcement strategies and hopefully to choosing the best one. Certain pharmaceutical trademarks are more susceptible to being registered as domain names by third parties. For example, trademarks of lifestyle drugs, including drugs that are often abused. I can think of things like Viagra and Ritalin, but also OTC drugs or drugs with a very large user population. This is definitely more the case than with the trademarks of niche prescription drugs, and the intentions behind these registrations also vary. Housemarks build a separate group. Because a housemark is primarily and by definition associated with the identity of a company, it attracts different types of abuse. Enforcement strategy starts with investigation to determine which of these categories apply, and we are going to go deeper into these scenarios that I mentioned later on. But at the end of the day, the truth is that you cannot do everything about everything. We all operate under resource constraints, internal resources or external budget constraints. So a strategy is also about picking the most relevant files. So back to you, Chris.
Great. All right. So brand protection kind of involves a toolbox of different, tools in your employ. Demand letters or cease and desist letters can be part of that. Brian, do you want to discuss how those can play into UDRP filings?
Yeah, and just to sort of pick up on something Maria mentioned and was interesting to see in the survey about kind of, being kind of intentional about the use of your resources. There was one of the categories was there was no active web page, and sometimes what we're seeing is even though there's no active web page, the domain name can be used for sending emails, and so that's something we're seeing an increase in. So something to be aware of. Just because you don't see an active web page doesn't necessarily mean that it's not something that you would need to go after. And I know Doug has some good tips on cease and desist letters as well. I think really just one observation is that we know that the UDRP is, as you say, one of the tools in your toolbox. It's kind of the tip of a big iceberg, and we if you can obtain the domain name through a cease and desist letter, then that's obviously more efficient. But it would say be prepared once you send off a cease and desist letter to follow through with the UDRP case. One practical tip would be, and we've seen this used to a complainant's advantage, is to take a screen grab of the domain name, of the website at the domain name before and after, because sometimes that changes. Someone, you send off a cease and desist letter and they change the content, and sometimes that's captured on the Internet Archive and you can find a historical record of that, but that's by no means a guarantee. So I would say that's my practical tip, is that not just to fire it off in blind, but to make sure you do a screen grab before and after, both on the one hand to preserve the evidence and then to see if there's been a change, which can also tell its own story.
And can I can just jump in? Is that okay, Chris and
Sure.
Brian? Just to piggyback exactly on what Brian was saying, and this gets back substantively sometimes to the UDRP itself. As I said before, that bad faith element requires showing not only the domain name was registered in bad faith, but that it is being used in bad faith. And so if at the time of filing the complaint, if that's what you end up doing after having previously sent a demand letter, the domain name is not currently being used in bad faith, then you may just need to make an extra argument, make it crystal clear as to how the domain name was being used previously. Another risk, though, and what I always tell my clients, who ask, should we send a demand letter, and I obviously to play the lawyer, the answer is it depends, and I don't mean to be silly, but it does depend on a case-by-case basis. How is the domain name being used? How important is the domain name to you? How quickly might you want it? Who is the registrant of the domain name? So there are a number of factors to consider. So there's no right or wrong answer. But there's also an issue occasionally with respect to what's called cyber flight. And this is not a term that we hear as much about these days, but not only could a registrant of a domain name change how it is being used after receiving a demand letter and before a UDRP complaint has been filed, but the registrant of the domain name could conceivably transfer the domain name to a different registrant. And then you're faced with the issue of having to determine whether the current registrant of the domain name is responsible for the actions by the previous registrant. So it's an interesting issue that you may just want to avoid by going directly to filing the UDRP complaint in the first place. On the other hand, as I also tell my clients, you never know what you'll get unless you ask for it. And certainly there have been plenty of instances in which cyber squatters have agreed to transfer domain names. And then one final point I would just add is that sometimes if bad faith is unclear, sending a demand letter might be worth considering to see what the response, if any, is, because there is precedent under the UDRP which says that a domain name registrant's failure to respond to a demand letter can in itself be additional evidence of bad faith. So it can help actually strengthen your case if need be.
Great. Okay. One of those tools that we talked about a little bit earlier was URS. Did you want to discuss that quickly, Doug, and how that can sometimes affect UDRP?
Yeah. So as I said before, the URS, Uniform Rapid Suspension System, it's a different policy from the UDRP. By the way, WIPO does not administer the policy. I don't know if Brian wants to speak to that or not, but the general point is it is not a popular policy. I track data in a digest that I publish every quarter, and I think there were 40-something URS decisions last quarter as opposed to over 2,000 UDRP decisions. The URS, in theory, is quicker and less expensive, and in practice probably is quicker and less expensive than the UDRP. But it has a higher burden of proof, clear and convincing evidence as opposed to a preponderance of the evidence. There are very strict limitations on what can be included in a filing with respect to both word count and the number and type of annexes. And the remedy for a URS case for a winning trademark owner is simply a temporary suspension of the domain name, as opposed to under the UDRP, where a trademark owner can get the domain name transferred to it, so the registrant, the trademark owner can then do what it wants with that registration, whether to just shut it down or to redirect it to its own website or do whatever they want. The URS will suspend the domain name so nobody can use it for the life of the registration, plus possibly one additional year if the trademark owner elects that. And then finally, I should add, and perhaps this may be one of the most limiting circumstances why the URS is not used more frequently, despite some of its advantages, and even if a trademark owner is willing to accept those limitations, and that's that the URS, unlike the UDRP, does not apply to .com domain names. So it does apply to all the new GTLDs. It applies to a limited number of sort of legacy TLDs, even applies to some CCTLDs, but it does not apply to .com. So a trademark owner who has identified cyber squatting in a .com space only has the UDRP as an option as far as dispute policies are concerned, and not the URS.
Right. Okay. Well, that's great.
Sorry, I'll add one very quickly. As a real life example, though, that speed is sometimes very significant. I just published a video actually earlier today about an interesting URS case for involving the Curb Your Enthusiasm trademark with the Larry David TV show. And in that case, the decision in the URS case came 16 days after the complaint was filed. Again, keep in mind under the UDRP, it takes about 60 days. But in that case, the URS was available because it was a .store domain name. Again, if you're looking at a .com domain name, you must use the UDRP as the only dispute policy.
Wow, that's a real fast result. All right. So one of the questions we did want to talk about that sounds on the surface like it's pretty straightforward, but actually has a lot of nuance, is the question of when not to file versus when to file. So Doug, in your introduction, you talked about a lot of the kind of base elements and things that are intrinsic to the process. What are the have-to-haves that you need when you want to really consider making a filing?
Well, I mean, I think the most important thing, and which is sometimes overlooked, is under that very first element of the UDRP, do you have trademark rights? And then under the third element, similarly, the bad faith element does not specifically say this, but the registration in bad faith essentially implies that those trademark rights need to predate the registration of the domain name, or at least the current registrant's acquisition of the domain name. So unfortunately, I've seen too many cases in which trademark owners may have trademark rights, but they did not accrue until after the domain name was registered, which typically means that the domain name could not have been registered in bad faith because the trademark rights did not exist at that time. So I would say that's probably one of the most common mistakes that trademark owners make. So usually the more inexperienced trademark owners who may be new to filing UDRP complaints, but even experienced trademark owners, sometimes who simply want to obtain a domain name, have been unable to do so through negotiation or demand letters, and then resort to filing a UDRP complaint. Keep in mind, the UDRP does not have a default judgment. So even though in most cases a response is not filed and it's referred to as a default, there is no default judgment. So the trademark owner cannot count on winning a case simply because a response is not filed. It still has to prove all three elements of the UDRP.
Okay. Brian, from the WIPO side, is there anything that complainants can kind of help themselves to do better when they're submitting their filings?
Yeah, and I wanted to pick up on Doug's point about the registration timing. We've seen more of these cases in recent years. There's a very narrow exception to this rule. It's not sort of hardwired into the policy, but it makes sense when you look at the black letter text of the policy and the cases. Is that the trademark rights predate the domain name registration. The very narrow exception is if there's, and there was a well-known case with the British footballer Wayne Rooney, and someone had registered a domain name corresponding to his name when he was a young up-and-comer, and it was before he had a trademark registration, but clearly the panel said that the evidence showed that it was registered in anticipation of his fame and his trademark rights. So, or there could be, I'm sure, Maria, you've seen this in the pharmaceutical sector, where there's a pending product launch that somebody catches wind of, and they swoop in and get the domain name before the trademark. Or what we've seen recently is people would watch the IP office trademark registers, and when that's filed before it's registered, they would get the domain name before the brand owner does. Now, of course, those are all reasonably straightforward because it's clear that this person was acting in anticipation of the rights and they're acting in bad faith. But the kind of counter to that is where there is no advanced knowledge. The domain name simply predates the brand, let's say hypothetically by 5 or 10 years, and there's just no facts that would support this claim to insider knowledge or something to that effect. And sometimes we see there's correspondence between the parties where the brand owner or their counsel kind of comes in heavy and says, this is our right, we demand this domain name. You registered it 10 years ago and you haven't been using it, and we have rights to it, and you should sell it to us for, usually it's an unreasonably low fee. And that's, I think Doug was kind of being kind to say it's a mistake. I think what we've seen in recent years is panelists are frankly losing patience for this type of scenario. It happens, in the big picture, not with great frequency, but with enough frequency to where panelists have said, look, even if you're not someone who practices this in your daily practice, there's the WIPO jurisprudential overview. This is there in black and white. You can find it online. It's free. It's available for everyone to use. There's no excuse for this. And they not only lose the case, but they usually would get what's called reverse domain name hijacking finding against them, which is kind of just let's say a slap on the wrist on paper in the decision, which might sound like not a big deal, but at least in the United States, and we've seen several cases where this happens, the registrant of the domain name, armed with that UDRP case where the brand owner lost, can actually go to the US courts and seek a declaratory judgment of non-infringement under the ACPA. And we've seen situations where the brand owner who filed that case that they shouldn't have filed actually had to pay 6-figure damages. So it's a pretty straightforward scenario that should be avoided. And it's one, unfortunately, that we do see people still file these types of cases. But just some of the basics are, look, these are the panelists are doing this for not a huge fee. Our fees haven't changed in the 24 years that the UDRP has been operational. Brand owners would like to see it reduced. Panelists would like to see it raised. We sort of say that the easiest path there is to leave it where it is. But really help the panelists out. Provide, and it's very basic stuff. Provide screenshots of the website at the domain name. Provide PDFs of your trademark registrations. If you are claiming unregistered rights, look at the overview. There's a list of things you can provide. And one thing I've certainly seen, coming from America and working in Geneva and seeing a complaint come in, and it's a brand that I've never heard of, but then you look at the papers and they're a bank in Turkey that's doing $5 billion in turnover, and they're well known across Europe. So don't assume that the panelist knows who your brand is. Really, and it doesn't take much. A page, a paragraph can walk them through. Here's our expenditures on marketing or client base, social media presence, whatever it is. But basically, don't make because panelists, they I would say as a rule want to get to the right result, but they also don't want to do your work for you. And sometimes they'll say, look, this is not my job to go search the trademark register of your national IP office. You haven't provided a certificate. Now, sometimes they'll sort of take judicial notice and do that. But again, it's the type of thing where it's easy to just do that and it's done. And so yeah, I can't stress enough that just making sure that you have the evidence that supports your case, and also be aware of respondent defenses. If you have a trademark which is a dictionary word, but it's your trademark, then be prepared to respond to arguments that this person registered it. Look, again, I said earlier, you can find a lot online. Does this person hold a portfolio of domain names? Do they hold domain names that are in a specific sector? Are they going to come in and argue that they registered this because it's a dictionary word and it had nothing to do with your brand? These are the types of things that you can anticipate in advance and argue. And it kind of goes back to that question of that might be a case that's not right for filing, especially if it's a short 3-4 letter brand or acronym. I remember when I first started doing this, a friend was looking for a domain name for a charity, and there was this one they found. I think it was a 4-letter .info domain name, and they said, yeah, I found this and it would be great, but somebody owns it, and they're asking, it was a couple $1,000 for it, and they said, this is outrageous. And I said, well, actually, it sounds pretty reasonable, and sometimes the smart move is to just acquire the domain name through a purchase and not file a case, because like I said before, you can actually find yourself not only on the losing end of the case, but in court defending yourself and even getting damages against you.
All right, that's some great insight. Maria, from a brand holder perspective, what would make one pause and consider taking other domain recovery approaches?
Yeah, Chris, this is what I was referring to before as the scenario analysis. I would say that there are two major scenarios when it comes to domains reproducing product brands. And then there are special considerations when we are talking about domains reproducing a housemark. I'll try to describe the scenarios in more detail now. And I will also offer some food for thought. These are not solutions, not one-size-fits-all solutions. This is really food for thought for the audience in terms of possible enforcement strategies based on things that we have been seeing in our real life. So scenario number one is what I call domain grabbing. So domains that are registered for no other purpose but to wait if the legitimate trademark owners will come and offer payment to recover them. It's an opportunistic practice, and there is no intention by the domain name registrant to set up a be legitimate or illegitimate business under the domain. The domain registration itself is the business model. Verifying where these domains are pointing to is the first step of our scenario analysis. So it can be a neutral parking page, it can be a for sales page, it can be a page with adult content or gambling. Then depending what is in there in this parking page, then I see this strategy going in a kind of a crescendo. So the default strategy would be wait and see approach. Monitor if there is movement at some point of time, if that page that is neutral or inactive becomes an active website dealing with pharmaceutical products, for example. And the UDRP in this type of case, because of the sheer volume that we see of domains with these characteristics, can be an interesting strategy, but primarily when either we need the domain ourselves or when the park page content is damaging. For example, if there is a very unpleasant adult content or something like this, and or suggesting drug abuse or anything like that. One less cost-intensive strategy than the UDRP that is always worth considering, and I heard Brian talking about cease and desist letter. Even if the cease and desist letter cannot be sent because we don't know who the domain name owner is, there is always this option of getting in touch with the registrar and trying to take the domain down. So inactivates the registration and cuts the link between the domain and that website. As a matter of principle, I can share with you that we do not pay to recover domains filed in bad faith. So we do not incentivize or encourage this type of business. URS, as Doug mentioned, have limitations. The URS can only be directed to certain top-level domains. There are other procedural constraints. So for you to have an idea about the statistics, in the last 3 years, Novartis filed 103 UDRPs and only 3 URS. Another thing that Brian mentioned is this domain grabbing, anticipating one of our naming projects. Basically, someone who sees that we have filed our very first trademark applications and move very fast and secure the domain names, mainly the .com. Just to put things in perspective, not only Novartis, but all major pharmaceutical companies have, for years in the meantime, a filing strategy in place that is meant to prevent this. So the .coms, they are secured either simultaneously with our very first trademark applications or even, 1 day before. So unless there is an accident, let's call it this way, this should not be a problem anymore. It used to be years ago. So this was about this kind of the milder scenario. Then we have the other scenario, which is when the domain name reproducing one of our product trademarks, and it can be either reproducing the trademark itself or containing the trademark, when the domain is actively used to host a site. And many times these sites are either selling counterfeits or they are selling unauthorized drugs. One thing that we have been seeing recently that it's becoming more and more common is sites that pretend to be selling pharmaceuticals, and but they are not. They look actually quite fancy. They are nice sites from a visual perspective. But when you try to buy something, the purchase act cannot be completed. So there is a suspicion that this new practice that is becoming more and more common has to do with the business behind that is not to sell drugs, be it genuine or fake drugs, but to fish for credit card information or other personal information. So these are the cases that require special attention. So these are the cases that do not allow for the wait and see approach that I talked before when I was saying, domain grabbing just for trying to obtain a big return on investment, paying $20 to register a domain and getting $5,000 to give it up. So this case with a reason active website behind it, doing something that it's not legal. The key for us is to work with investigators, be our own internal in-house investigation team or with our providers, and because we need to understand the technical setup of the domain name. We need to understand the content of the website. We need to understand if there are links that are not visible to the common user to other domains and to other sites, if there are background activities going on. So investigations are key, but they are also very complex, and they have to be conducted by intelligence experts. So this is outside the realm of activity of the legal brand protection team. So this is very important, and someone mentioned before in the panel, because we need to take a holistic approach in terms of enforcement, this means necessarily working with other teams in the company and working with experts outside the company. And another very important thing in this case is, it's absolutely key, is cooperation with law enforcement. And in this particular case, when there is complexity and trying to recover the domain, be it through a UDRP, be it through a cease and desist letter, can even be counterproductive in certain instances, because it may cause a setback to the investigation and to broader enforcement efforts. And the reason is that by removing that domain name by either recovering it or putting it offline, we are basically closing that gateway, that intelligence gateway that it's needed for those investigations to proceed. So these are things that that need to be planned carefully. So I certainly do not recommend any kind of actionism of, just go and start sending letters out or filing this or that type of action. Sometimes you just need to be patient, and you need to invest the time and the resources to really figure out what is going on. So this was scenario number 2. And the third scenario is the one concerning the housemark particularities. The housemark of a pharmaceutical company will likely be targeted in a different way, and illegitimate registrations may have additional purpose, and I think that Brian mentioned this also. For example, certain domains, they are registered just for MX records to be set up, and the whole purpose of the exercise is phishing, sending out phishing emails, and even setting up websites that apparently look genuine. They are nice, they are fluent in reading without considerable potential website. That's not a website or not a legitimate online website. This is a new trend, but it's a new trend that has become common. It's new, it's become quite widespread very fast, and there are already everything out there.
Yeah, I think we're having some audio problems. I don't. The last you broke up the last few seconds, I think.
So I'm going to talk now about what you're seeing in terms of the phishing domains registered for phishing for information, and either through emails or through websites. So we have seen cases recently where a website is set up under a domain name containing our housemark, and that website has some connection to HR, to jobs, to careers. So people go in there thinking that they are going into one of our websites.
Maria, unfortunately, I think the audio problems are continuing. So I think maybe we'll discontinue that for a second.
Is it at my end? No, right?
Yeah. Oh, you were clear just a second ago. Were you almost completed with that point, or was there more?
Well, I was actually about to finish, but can you hear me at all?
You're better now. I mean, if you can wrap it up in like 30 seconds, that'd be great.
Okay, I will. Yeah, so essentially this is the method that in this case, this strategy is to cooperate with anyone who has been damaged. The damage is not necessarily against us, the company. We don't suffer the financial damage, but we may suffer the reputational damage. And we need to be careful in terms of data privacy. If someone turns to us saying that they have been contacted by or they tried to get into the website and it was not our website, so disrespect for data privacy, because at the end of the day, the bottom line is as a company, we have a responsibility towards society, so we cannot simply ignore this type of practice because we are not suffering a financial damage. So this is the nutshell message for this scenario.
Okay, great. All right, well, thanks for that clarification on your scenarios. So in the interest of time, unfortunately, with all this wisdom, I think we maybe bit off a little more than we could chew. We'll jump to a question or two, and then there are a number of questions in the chat. We will send out a recording, and we'll send out some follow-up information on that. But let's just do one or two real quick just to kind of answer a few things. Here's one that says, to what extent, in your opinion, should content of a website by the disputed domain name be relevant for confusing similarity analysis under the first UDRP element? Does anybody have a take on that?
I'll jump in quickly, and I think actually this is addressed in the WIPO overview that Brian was talking about before, which is, just a wonderful resource. Doesn't address every topic, but it addresses a lot of them, and it touches on this topic. I don't have it pulled up in front of me right now, but I think In general, if I recall correctly, what the overview says is that under certain circumstances, it is appropriate to look at the content of a website and assessing that confusing similarity evaluation. And that's because it shows how a domain name is being used can itself be evidence of confusing similarity. So typically, confusing similarity is a side-by-side comparison. On one side you have the domain name, on the other side you have the trademark. But sometimes it is useful to look at the content of the website to either affirm or deny confusing similarity.
All right, great. This might be for you, Brian. Someone had a question about, do you think that a 4.0 version of the WIPO overview is necessary soon? I don't know if you can comment on that.
Yeah, I think, we've obviously looked into this. I think what we're more likely to see is a version 3.1. The truth is we did a ground up rewrite back in 2017. It was about 2 years in a lot of research and drafting in the making. Candidly, not much has changed since then. So we've identified maybe a half a dozen issues where there might be a need for a small update. But I think it's likely to be much more incremental because I would say 95% or more of what's in the overview still stands today.
Okay. Let's do one more. This one is talking about, they come across cases where they're kind of the hallmark characteristics of a scam, like really bad websites, typos, that kind of stuff, but they can't actually really come up with concrete evidence of the scam. Any idea or best practices on kind of how to incorporate that into the complaint?
That's something we've seen, and I would even say, the fact of the way the website's been described itself could be evidence that can indicate that something is off. If I go to a website as a shopper and I see a bunch of typos, or a lot of times you can find clues in the contact information. So we saw a case recently where the contact information was something like 123 New York City or something to this effect. So I would say there's definitely clues in unprofessional, unpolished looking content. And then another thing that we've seen is you can sometimes find, if you take a section of the text and you have to play around with this, right? It could be 5 words, a sentence, a paragraph. But sometimes if you take a section of text, plug it into Google, it'll come up with results that say this same text is appearing on a dozen other websites, and you can start to kind of look for breadcrumbs there.
And sometimes the website of the trademark owner itself. So they're copying content from the trademark owner's own website, which can certainly be misleading.
Okay. I think we'll end with the Q&A for now. We'll try to provide some notes in our follow-up materials to some of the answers that didn't get addressed. We did advertise that we were going to talk about AI. Let's just do a quick speed round, 30 seconds for anybody if they want to comment on what they're seeing in the AI space right now. Do you want to start, Doug?
.ai is a top-level domain for Anguilla. It is subject to the UDRP. So it's one of those 40-something CCTLDs that participates in the UDRP process. That is very helpful for trademark owners. The number of .ai domain name registrations has certainly been increasing lately. Chris, I know you track this. The increase in the number of UDRP cases involving .ai domain names is at this point sort of modest. But I certainly think that just like .tv has appealed to the television industry and .md to the medical doctor industry, .ai is something that is appealing to the artificial intelligence industry, and I would not be surprised to see an increase in cyber squatting activity.
Anything from you, Brian? 30 seconds.
Yeah, I would say obviously we're hearing a lot of judges and lawyers playing around with it. Certainly be careful of hallucinations. I think, Doug, you did a video on this in your series. And then kind of going back to that question about looking for clues for websites where they may look legitimate. Again, this is something where I suspect that this is going to become more difficult. I'm sure there's going to be tools developed to try to size up if something's automatically generated, not that that necessarily makes it bad faith, but that might be a clue that this is someone who's an infringer versus a legitimate reseller, for example. So it's obviously shifting in front of us, but look for website content where that might be in play.
Great. Maria, any comments on AI, or are you good? Oh, looks like we can't have your audio. I think we're continuing to have some technical problems. Okay, sorry. We can still see you. We just can't hear you. All right. Well, let's. Any last kind of thoughts as we've gone over time a bit. Any particular takeaways that we want to leave folks with? Doug, your thoughts?
Don't take the UDRP process for granted. On the one hand, it's not rocket science. On the other hand, it's not a fill-in-the-blank form. A UDRP complaint is, as I tell my clients in the United States, not like notice pleading in U.S. courts. It's more akin to a motion for summary judgment. You need to include all your factual and legal arguments in a UDRP complaint. And I've seen too many complaints that take too much for granted, don't provide all the facts, don't cite relevant authority, and the best complaints are well researched, well organized, and thorough.
Great. Brian, your thoughts on takeaways?
Yeah, similarly, I mean, obviously use our overview, but I would say, yeah, don't treat these all the same. Not every case is the same. It's tempting because we understand that there's a lot of pressure on budgets and there's more infringements, but it's worth having a process in place to know when does a case need a deeper human review, knowing who's on the other side. So it really just, yeah, you can't treat these all as a one size fits all, and you have to have a process in place to know when to look deeper.
Great. Maria, we still having audio problems? Oh, looks like it, unfortunately. Okay. Well, I think, as someone said, with 3 years of practice of this, we're still having issues with Zoom calls and things. Anyway, I guess with that great, feedback, thanks everybody for coming. Again, I want to really thank all the speakers, Maria Fernandez Marquez of Novartis AG, Brian Beckham from WIPO, and Doug Eisenberg from the Giga Law Firm. Thanks for all your, great insights and experiences, and that you gave, our viewers a ton of information about the UDRP. I hope, thanks again to the viewers for attending. I hope they learned as much as I did. You guys are just found some wisdom, and we appreciate everything you told us. A housekeeping point, we will be providing a quick survey as soon as the webinar closes, so you can give us feedback on this as well as other, topics you'd like to see. And look for other content coming out from us in the remainder of the year. We're looking to hit things about the next round of new GTLDs, Web3 podcasts and other things as well. So, keep coming back to the Markmonitor, and we'll provide you information on our resources page. So with that, thanks to everyone. Good morning, good afternoon, and good evening. Bye-bye.